What does the market look like for ATE insurance at the moment?
So the AT insurance market is fairly London centric. The genesis of ATE insurance was the PI, the personal injury and insolvency space. And now over the years, that has grown significantly to include some of the largest and most complex commercial litigation that currently is taking place. In terms of its use beyond London, we are aware of and indeed have been involved in arranging insurance for various jurisdictions such as France, Spain, Germany, and even in places as far as Canada and BVI. So it's used, fairly extensively in all types of cases and in various jurisdictions and forums, even in commercial and investor state arbitrations where public international law is applicable. So there's a growing appetite to consider cases in different jurisdictions under different applicable laws. However, there is a limit to how much insurers are able to do, given the limited resources they have and the costs associated with underwriting and then subsequently monitoring a risk. That is particularly where the language of the proceedings, as well as the underlying case documents, are in a foreign language. In these circumstances, I think the involvement of a funder that does have English language capabilities, as well as whichever foreign language the claim is extremely helpful. As the reality is, they will do a lot of the heavy lifting. And as long as the insurers have faith in and they have an understanding of the fund's capabilities, quite often they will almost rely on the funder as like a lead underwriter to a degree. So I think that's something that's, we've seen take place and happen over the years. The key thing is, from the insurer's perspective, is A, they need to be able to understand the risk sufficiently such that they can underwrite it. And B, or part two, is being able to continue to monitor its progress in order to protect their position effectively as de facto passive investors in a case. So I think those are the kind of the key relevant factors. And one final thing I should add, which can cause a bit of annoyance sometimes, but is the reality post Brexit that we have to deal with, is the licensing and regulatory restrictions sometimes that apply. So if you have an insured which is domiciled in Europe in the EEA, unless the insurers have a specific license to allow them to insure European claimants, they simply won't be able to assist. And, most insurers now, I think, well, a number of them, I should say, have now got post-Brexit transition arrangements in place which allow them to do these, or they have certain workarounds. But, it's definitely not the case that it's as easy as it was before, unfortunately.
So post Brexit, UK solicitors don't have standing to represent clients in the UPC, but European qualified patent attorneys do. If the market is narrower for ATE, for European claimants, would there be a potential route for a law firm to provide an indemnity and to obtain, better terms if the ATE cover is given to a UK-based law firm?
That's a great question, Emily. I think whether or not it would be more cost effective or better value by having a law firm provide an indemnity, I'm not sure that it would. I'm not sure if it would make any real difference. But in terms of the universe of potential insurers that may exist or be available by virtue of having a law firm which is in a domicile which the insurer is able to provide cover, I think that will definitely help. And I think the insurers will be quite happy, as we've seen in the past, most insurers are anyway, quite happy to insure law firms or other entities such as litigation funders who in turn will, provide indemnity to the claimant. So a back-to-back scenario. So yeah, I think that is definitely something that insurers will want to consider.
What are the typical terms that litigants could achieve for ATE insurance in the UPC?
So I think it's difficult to say precisely at this stage, given we don't know what the shape of the UPC court will be. And I mean, I understand there's going to be akin to what we have in certain jurisdictions like Germany, if I'm not mistaken, where the level of recoverable costs will be dependent on the level of damages sought to a certain degree, if I'm not mistaken. So I think without knowing exactly what the shape of it is, it's hard to say. But I mean, to kind of give you a rough idea as to kind of how it's currently priced in all the other jurisdictions that we work, there's usually three kind of pricing models. The first is a fully upfront deposit premium insurance policy. So similar to how you might pay for any other type of insurance in your life, whether it's your car or your home, whatever it is, you pay a one-off premium. That premium is usually based as a percentage of the level of cover. So if you're looking for, I don't know, €1 million of cover, you may expect to pay 30% of that as an upfront premium. And, once you pay that premium, the cover is in place and there's no further payments to the insurer. And if you win, that's great. If you lose, then the cover pays out. So that's kind of, the very vanilla, simple model. The more common method is, partially paid and partially deferred and contingent upon success. So in this scenario, again, there'd be a deposit premium to be paid at the outset. That may be in the range of 10 to 15%, for example, of the level of cover. And then there would be a slightly larger premium to be paid, but that would be contingent upon the case actually succeeding and a recovery being made. And that premium is what's called a deferred and contingent premium. And those premiums are usually staged. They are staged in a way to incentivize early settlement and to ensure that the premium is proportionate to the damages being recovered. So again, as an example, a deferred and contingent premium may have two stages. The first stage being prior to the service of statement of case, and the second stage being prior to the service of expert evidence, for example, or indeed a period before trial at the final hearing. And if you settle at the first stage, the deferred and contingent premium may be an additional 20%. So in total, you paid the 15% upfront. And then if you settle immediately after statement of case, you pay an additional 20%. But that payment comes from the recovery of the damages. So it's not a payment that the claimant has to pay upfront. And if, however, the claim goes long and it doesn't settle and it goes past the second stage of the deferred and contingent premium, you may find that you pay an additional 35%, for example, of the level of cover. So you paid the 15% upfront and, a late stage settlement or indeed, if it goes to trial, an additional 35%. So in total, you may have paid as, a 50% premium of the level of cover. That's the most common method that we see of pricing in ATE insurance generally. The third pricing model, which is less common in, larger disputes or disputes that, are less straightforward than, for example, insolvency type claims or, very straightforward and small claims, that is a fully deferred and contingent premium. So that's where the claimant pays nothing upfront whatsoever. The premium is entirely contingent upon success. And again, that is quite often staged. So depending on when the case settles, that will determine the level of premium being paid. And if the case is lost, then, the claimant hasn't paid anything at all from their pocket. However, they have benefit of the cover such that the opponent's costs will be covered.
How common are the different types of policy structure? So a fully deferred premium, could that be available to SMEs, for example, litigating in the EPC, or are there specific claim types which that lends itself to more?
So fully deferred and contingent premiums are usually reserved for claims where the level of cover sought is less than 500,000, let's say. So, if you have a claim where the level of cover is less than 500,000, it's quite common to be able to, procure those kinds of terms. Again, and those cases are limited usually to very straightforward cases. So, your insolvency claims or, simple contractual debt claims. I think if we were to start looking at intellectual property disputes, whether it's, soft or, hard IP, it's not really an area of law that underwriters are hugely familiar with. And they are inherently more complex than your average insolvency or, debt claim. So I think for those types of cases, I would be fairly surprised if an insurer was willing and able to provide a fully deferred and contingent premium, out of the box at the outset. Having said that, insurance is very much data led. And as things develop, as the UPC is used more frequently, and, we start to develop a greater data set around settlements and likely success rates and those sorts of things, then it's very possible that insurers may look to consider some sort of fully deferred and contingent scheme for volume type cases. But again, that pricing model is geared more towards small, simple volume cases.
So, how do claimants go about securing ATE? Where do they go to look for that? And what do they need to put forward in terms of information for an insurer to be able to underwrite?
So In order to obtain an AT policy, a claimant or indeed a defendant will need to approach a broker. They will need to provide the broker with all the relevant case documents. So usually that will look like, a typical pack, a merits opinion from the law firm involved or from independent counsel, any preliminary expert evidence that may exist, any pre-action correspondence. So, all the key documents that are relevant in the case that will allow an underwriter to underwrite the risk effectively. So for them to understand what the case is about, who it's against, and what the likely prospects of success are. So, it's really the same things that a funder would look for, that firstly, the claim has good prospects. And, usually insurers expect those prospects to be expressed in percentage terms. So they'll say, we are looking for cases where the likely prospects of success are in excess of 60%. They'd want to ensure that the damages are proportionate to the amount of cover that's sought, to ensure that the claimant has enough left at the end of the day to make it meaningful. And finally, to ensure that there are good prospects of making a recovery. So, the best case in the world, if it's against a defendant that doesn't have the financial means to satisfy any award or any settlement, then from an insurer's perspective, that's not an attractive risk. So again, it's very much the things that a litigation funder would also look for.
So, Mo, what's the ATE market like for patent cases?
Fairly limited, but not non-existent. So patent cases, like any hard IP disputes, are technically and legally complex. And given where the AT market, its genesis, where it's originated and has subsequently developed to, it's not an area of law that many underwriters are proficient in. Um, Having said that, AT insurers are not expert in every area of law that they write insurance in. They will rely on the legal and experts' opinions obtained by the proposer, and occasionally will commission external advice of their own to support their underwriting. And, to my earlier point, this is another reason why having a litigation funder that does have IP expertise, who's effectively able to lead on underwriting, can be so valuable to insurers. So while the current market for ATE in patent cases is fairly limited, much like how we've seen ATE develop from the PI insolvency market to now large-scale commercial litigation and investor state arbitrations, if the demand exists, the expertise and the appetite will follow, and I'm, fairly certain of that. So, Emily, I've got a question for you. In your view, given the notable exclusion of Spain and Poland and non-EU states like UK, Norway, Switzerland, and Turkey, how successful do you think the UPC will actually be in its aims to achieve harmonization across Europe?
I'm quite excited about the UPC because, from a funding point of view, it will increase the level of damages. So, yes, not all of the European states are in, and then the non EU states, notably the UK, which is a big patent litigation centre. But I mean, even, expanding the number of jurisdictions which are covered by a particular claim to two or three is still going to increase the level of damages, and economics is important from a funding perspective. I think that the jurisdictions which are not in, excluding the UK and Spain, may not be sort of common jurisdictions for patentees to have validated their patent. So if you're in the tech sector, for example, you probably, validate in some key jurisdictions like the UK, Netherlands, Germany, France, Spain, Italy, and not probably more broadly. So the fact that a couple of those are not in does mean that you're not going to get coverage completely across all of your EP patents, but you're still going to increase the damages enough. And actually, in those sectors, that's normally enough to bring a resolution globally, because most organizations don't want to have two tiers of product, one for the sort of market that's covered by a patent and one for everywhere else. So I think it could be quite a successful court, but it's going to depend on how the judges apply the new rules, how people sort of interact with the court. So there's decision making now as to whether people need to opt their patents out of the court, so it's not part of the system and they stay in the national system, or whether they leave them in. So I think the profile of the patents which are remain in the court will be important, and hopefully there will be some sort of more valuable patents remaining in the court system. Speaking to other experts, I understand that, pharma companies are going to opt out all of their crown jewel patents. So the quality of what's left for in that industry might not be the highest or the most valuable patents, but potentially understandable where a patent covers an entire product and it's a new untested court with untested rules. So I'm excited, but we'll wait and see. So Mo, are we going to see after the event insurance in the UPC?
I think yes. The question is when, given it's a new system with new rules, new processes, procedures, everyone will need to get a little bit of time to get their head around how it will work. But once they do, and that will largely be led by claimants, lawyers, and funders, the insurers will inevitably follow. So as long as we see the appetite, the insurers will eventually catch up in terms of expertise and willingness to get involved.